Good afternoon in Sonipat. I know we are all in different time zones. And a very warm welcome to all of the distinguished panelists today. The topic for the dialogue today is culture of constitutionalism, the globalization of constitutional law. We have with us today Professor Gavin Phillipson. He's Professor of Bristol Law School at the University of Bristol. We have with us the Honorable Mr. András Sajó, former judge, European Court of Human Rights, Strasbourg, and Professor of Law at the Central European University in Hungary. And we have with us Professor Adrienne Stone. She's the Redmond Barry Distinguished Professor and Director, Center for Comparative Constitutional Studies at the University of Melbourne. So I'll just give a very brief introduction to the topic, and then I can address the questions to each of the panelists. And if you have comments or any of the other panelists would like to comment, that's fine as well. And in the last 15 minutes, we'll have questions from the audience as well. So globalization is the umbrella term that is used to capture the enormous increase in the flow of people, capital, goods, services, and ideas across national borders. During the age of globalization, many areas of law appear to be subject to some degree of harmonization and standardization. However, the field of public and constitutional law is often viewed as one in which public law arrangements they seem to be designed as much in dialogue with the past as with the future. And that past is likely to be pretty nation specific. So public law systems are often seen as being deeply embedded in a certain social and political history, and references to constitutions are seen as a return to the local and the national. States and their citizens have relied on constitutions whenever and wherever there was an overreach of globalization. However, certain contemporary trends that have emerged in the field of constitutional law reflect the effect of globalization. So, for example, there is the phenomenon of a constitutionalization of international law through treaty becoming constitutions, and the internationalization of constitutional law through such means as the incorporation of international human rights treaties into domestic constitutions. As a historical matter, constitutional discourses predominantly, but not exclusively, occurred in the domestic legal setting. However, recent years have witnessed an intensification of constitutional discourse in many sites of transnational governance. Increased globalization makes it more valuable for actors to enter into denser legal and institutional relationships, including constitutionalized relationships. Indeed, there may be a dialectical relationship between globalization and constitutionalization along the following lines. Technological and social change yields greater possibilities for beneficial international interactions, including international commerce, but also increasingly now international environmental stewardship, international cooperation to combat organized crime, and so on. International legal rules become more valuable to realize the increased benefits of these international interactions. This increased demand for production of international legal rules gives rise to an increasing demand for international constitutional norms and processes that facilitate the production of these international legal rules. These debates over transnational constitutionalism occur as the international community continues to adjust to the end of the bipolar era in the context of a highly diffuse and pluralistic processes of global governance, and at a scholarly moment which consists, as David Kennedy notes, a moment which is both of great unknowing and of disciplinary reinvention. The prominence of debates over constitutional orders beyond the state reflects larger patterns in international relations, including the increased density and reach of international norms, increasing importance of new legal actors in international legal processes, and the rise of new topics of international legal regulation. And there is also an increasing sense that some of these developments threaten elements of domestic constitutional structures. So with this background, I'd like to go to the questions, and perhaps I can address the first question to Professor Phillipson. Would you be interested, or Professor Stone? I'm not sure. I know that you didn't indicate preference for that. So I don't know if you would prefer to answer that, or if I could address that to Professor Sajó. So there are several influential strands of thought that suggest that pressures for international constitutionalization are a product of globalization and the accompanying increase in the reach and density of international legal norms. So how can this claim be examined critically? To what extent does globalization actually drive constitutionalization in international law? So I can ask Professor Sajó, or it could be Professor Phillipson, perhaps.
Well, let me just say, I think briefly, because I'd really like to hear what Professor Sajó has to say on this. But my sense is that it's important always to remember that constitution making has always been, to some extent, an transnational affair. So I live in a country with one of the oldest constitutions in the world, relatively unchanged for 120 years. So its origins are way back in the history of constitutionalism, yet but very much a transnational affair. Australia was particularly obviously influenced by its heritage from the United Kingdom, very influenced by the United States, and at critical points also very influenced by the Swiss constitution. So I think that this has actually always been with us, this transnational, the transnational nature of constitutions. There is this sort of myth that's in our constitutional theory of a constituent moment when the people come together and make their own political settlement. Now, it's an important myth, and it might be particularly appropriate in certain kinds of contexts, but I think it's always been much more complicated than that. So if you look at the Australian Constitution, it does not at all fit that model. If you can think about a constitution that was formed in a post-war context all the way back in the middle of the last century, like Japan's, also doesn't fit that model. So you don't have to look very far to look for really long-standing evidence of transnationalism in constitution making. And so I would say that it's not a new development, it's a fundamental part of the phenomenon.
Any comments, Professor Phillipson or Professor Sajó, or should I move on to the next question?
I suppose I was just thinking in relation to the UK's own constitution, or lack of a constitution, that it was a sort of peculiar feature of Britain's colonial past, that it would kind of, as it were, give written constitutions to the countries, to the dominions as they were known, while refusing to do so for itself, and at the same, thereby kind of undermining some of its own arguments against having one itself, particularly in relation to being a common law system, which then gave birth to several successful constitutions in countries like Canada and Australia, while declining to do so itself. I'd say that Britain remained relatively, in that sense, kind of resistant to international influence until around about the 1970s onwards, when there was an explosion. Obviously, the European Convention on Human Rights in 1950, but that started very slowly to have influence and really kind of exploded into life, not till about 20 years later or so. And then, of course, the European Union, which all, despite Brexit, which I'm sure we'll probably mention again, continues to have an enormous influence upon the UK constitution, as well as, of course, globally as well. I think the global reach of EU law is something that I'm sure we'll come to well beyond the European Union.
Yes, and in India, I mean, although, as Professor Stone was saying, we do kind of have this symbolic moment of, the Constituent Assembly sitting and drafting the Constitution and so on. There are scholars who still think that the Indian Constitution actually reflects the Government of India Act of 1935, which is a British statute, actually. And we had Professor Dr. B.N. Rao. He was the constitutional advisor to the Constituent Assembly, and he actually went around the world looking at constitutional precedents. So he has a book called Constitutional Precedents, where he went to the US, the UK, Ireland, Japan, and he came and kind of discussed all these ideas with the Constituent Assembly. So yes, so I think, as Professor Stone was saying, it's not just at this point in time that there is this kind of transnational influence on public law. It's been happening for quite some time.
May I add something
yes,
to this?
yes, of course.
Because I come from a continent where there is probably more integration to a at least regional network of constitutionalism. So first of all, the history of constitution making, at least, well, going back to ancient Greece, but certainly beginning after World War I, it was always related to comparative studies, and foreign influence did play a role, except that this was always something instrumentalized. So yes, there was always reference to foreign examples, but which one to choose, that was the really interesting issue. So it was a major source of legitimation. In many countries in Europe, and of course South Africa, the contemporary approach is, and this is constitutionalized to different extents, that foreign experience matters even in a normative sense. So either the Constitution has provisions that foreign or international experience has to be taken into consideration, or a judicial practice indicates that a pick and choose reference to international development. So it is present in many different ways. What I think is also very interesting to note that this more intensive presence of a international, I wouldn't call it global dimension, is multi-layered. So it's not just that you have a number of constitutions you refer to, regional human rights or other then UN conventions. And once you get into these, you see that there is an enormous internal tension. And that creates a very specific new dynamics in constitutional law as applied and also as it is written, because it is so complex that a country that is supposed to exercise its sovereignty in reality chooses what kind of model to follow. So that's a new meaning of sovereignty. It's do you allow this kind of influence to enter or that kind of influence to enter? And with a re-emergence of the idea of sovereignty because of growing nationalism, this choice becomes even more important. It becomes a matter of rejection too. So in the name of sovereignty, you hear these days that this global constitutional influence or regional constitutional influence is contrary to sovereignty. We are not yet discussing the normative aspect, but I just wanted to highlight how complex this relationship became. Thank you.
Yeah, so I mean, usually I've also read that you have these legal families forming, where there's, from the disintegration of these previous colonial empires. So the German colonies would kind of look to Germany for the prototype, or the British colonies would look to the Westminster model as the prototype. And, so India, for instance, adopted the Westminster model with a little bit of difference, because we have a written constitution and Bill of Rights and judicial review and so on, and we have a federal constitution as well. So there is also, I think, I mean, in terms of classification, we try to kind of classify constitutional systems based on the prototypes that they followed when they drafted their own constitutions. But you're right, it's a very complex process in terms of asserting your sovereignty and at the same time trying to learn from the experiences of other constitutional systems that were kind of iconic precedents. Any further comments before I move on?
I suppose the example that comes to mind of a country that has stubbornly resisted external influence, particularly in constitutional and constitutional rights matters, is of course the United States. which has kind of fiercely resisted, and even as I think one of the questions we're coming to, but you get very heated debates in the Supreme Court as to whether it's even permissible to cite kind of any form of foreign law as kind of any possible useful guidance, and some justices and indeed law professors in the United States are kind of very, very resistant to that. But I think what's interesting is not probably as a result of globalization, but as a result of exceptionalism in certain stay of US libel law, which is a standard that, to my knowledge, no leading democracy has copied, because it's thought to be too extreme in enabling kind of, completely vicious attacks on public figures, provided that they only are a public figure. But that, I think, now being called into question in the light of the Trump experience and the kind of prevalence of the big lie in the United States. So it'll be fascinating to see whether the US ends up somewhere closer to what you might think of as a kind of European/Commonwealth consensus on a more kind of moderate balance between, in that case, sort of free speech and reputation, but across a whole range of areas where the US has stubbornly maintained a very, very different course in many areas of free speech, including hate speech from international consensus and both international human rights treaties, and from which it always enters reservations, and also comparative norms.
Yes, we'll be coming to the problem with judicial, the judicial kind of, if the judiciary can look to foreign precedents, we'll be coming to that question. So perhaps we can move on to the second question, which is, what are the significant sides of transnational governance, and what are the implications of international constitutions? Are constitutional orders beyond the state conceptually coherent and normatively desirable? And what is at stake in debates over global constitutionalism? Professor Stone, Professor Phillipson, would you be interested in?
I've insisted Professor Sajó take that one, I would think.
Okay.
Just very briefly on the normative aspect. So if you believe in separation of powers as a tool against tyranny, then the internationalization or globalization, where you have additional veto players, is a great addition. So it's normatively justified from that perspective. It is just another element in this separation of powers dynamics. And I think that's a sufficient reason, notwithstanding all the complications and complexities and abuses. I think that there is a very strong reason to endorse it and consider it a major contribution to constitutionalism.
I've read of articles where the UN Charter is often seen as being, something on the lines of a world constitution. So, is that something that you would also agree with, Professor Sajó?
Well, I think that it set into motion or enabled a certain trends. The Charter itself, it's hard to say that it is of direct relevance. It gives certain inspiration about the use of force, for example. So it has a tempering influence, but I mean, in terms of being applicable domestically, I would say that is not a primary mover. What is a primary mover is the whole system that is developing out of the UN system on the basis and in the spirit of the Charter.
Comments before I move on to the next question?
I was just wondering, could we say that bodies like the UN and the all the treaties that have come from it, including the various human rights treaties, are a source of international law, but only the European Union has attained kind of internal constitutional status? In other words, is a constitutional order beyond the nation state, whereas bodies like the UN and other international bodies simply are sources of international law, not constitutional law themselves. I just throw that out in case anyone wants to comment on that.
Yes, you have so many regional pacts, so you have ASEAN or you have NAFTA or something. So none of them kind of really approach the constitutional law-like features, I think, of the EU system, right? Is the development of constitutionalism beyond borders the most developed within the EU?
I would say so. Yes. I mean, I'm often struck when I visit other common law countries like, say, Canada or Australia, whether the fact that the kind of the deep interpenetration of European Union law directly into not only domestic law but constitutional law. I mean, the EU claims that the EU law has a higher status than any national constitutional provision, which is obviously being challenged by several states at the moment. But I think that's a kind of unique. That's a unique claim made by an international body to actually override not just normal domestic law, which for dualist states would not be permissible unless they've chosen to implement it via domestic legislation, but also to override even core provisions of their own constitutions is a remarkable claim. And I can't think of another international body that seeks to make that claim.
May I make a comment just going in the opposite direction? I think it's important, if we think of Professor Sajó's point, that what supranational constitutionalism can provide is another veto point, right, for the unitary state. But the same can be done by subnational units. And I have just been so struck in Australia over the period of the COVID pandemic of how it has been state government that has been really at the forefront of dealing with this and really, really prominent. And I would also like to say that I think, turning from my own country globally, that I think that cities and city governance is likely to become extraordinarily important over the next century with the growth of megacities throughout the global south that experience problems in their own distinct forms, that I think that there's good reason to both seek to empower cities and expect that cities will be seeking to empower themselves. So I wonder if the story of the 21st century, or part of it, might be a reinvigoration of the subnational.
I think Rand Herschel has just written a book on cities or megacities being the location of constitutionalism. I haven't read the book yet, but I believe that's the subject.
I have read it and I recommend it to you.
Okay. Okay. Okay, so if there are no further comments, I can go on to the third question. I think Professor Phillipson said you might be interested. How is the emergence of international human rights treaties and conventions and regional arrangements? I think you've already addressed part of this question. Arrangements such as the EU impacted or affected domestic constitutional systems, and what are the interrelationships that connect these systems? Would you like to go a little further in detail into this?
Well, again, I think there I'd be interested in András's comments on this, but I mean, I would sharply distinguish the impact of something like the European Convention on Human Rights, which also, of course, has a much larger and more kind of disparate membership, and the European Union. The ECHR, although it's been perhaps probably the most effective human rights treaty globally in terms of actually kind of resulting in changes to domestic law in general. Kind of international human rights law suffers from a kind of chronic weakness of enforcement. So the right of individual petition, where citizens can themselves go to the court and then their countries will change the law in response or provide some other remedy, I think has been kind of uniquely effective. But it does operate within a conventional dualist system. So it doesn't require its own incorporation into domestic law. It operates for dualist countries in an orthodox way, in that the judgments of the court are binding on the state qua state, but do not themselves alter anything in domestic law. Although countries can choose to give effect to them, as the UK did in 1998. So that, as compared to the European Union, which claims obviously direct effect and supremacy as the kind of two fundamental features of its law, which is interesting, neither were in the original treaties. A little bit, I've always thought there's a little parallel there with the fact that the strike down power for courts in the United States was not actually written into the Constitution but was obviously famously declared in Marbury and Madison, that neither the doctrines of direct effect nor supremacy over domestic law were actually explicitly stated in the Treaty of Rome, but were essentially developed by a court. So the fact, yes, it's a direct challenge to dualist states. It's a direct challenge to national sovereignty, obviously, and it's a direct challenge to the national constitutional order. If the national constitutional order seeks to see itself as being the supreme source of law in the country, which of course is the general view. And even in the UK, with its unwritten constitution, membership of the European Union challenged the central tenet of parliamentary sovereignty, of the unlimited lawmaking power of Parliament, because it was necessary to find a way for Parliament sovereignty to be in some way restrained, so that the UK would indeed act compatibly with European law and would give effect to European law over domestic law, which was a major challenge even for the UK's unwritten constitutional order. So in that way, yes, I would see the EU as unique as a regional system.
So do you think Brexit is likely to be, rethought at all, or do you think this is something final, in terms of just the assertion of British sovereignty, or something like that?
I mean, I think what we're realizing about Brexit is it's a continuous process. So, I mean, as to whether the UK would formally rejoin, I mean, I would personally hope so, but I'm done with predictions from the experience of the last 10 years. Yeah. I think what we will see is perhaps a continued kind of struggle. I think, if a Labour government ever takes power, for example, in the UK again, they would want probably to seek a closer relationship with the European Union. You might then get another government coming in which wants to distance the relationship. So I think the relationship will remain one that is embedded in law through the withdrawal treaties, and will be continually, I think, may be continually renegotiated over the next 30, 40 years. As for the longer term future, I have no idea, but European Union law has been retained in the UK, so it will, even though we've left, EU law is still an enormous source of law in the UK, although it's now called EU retained law, and its exact constitutional status remains to be worked out. So even there, where you look like you've had an abrupt reversal, it looks like a kind of aggressive reassertion of national sovereignty over, a global constitutional system or regional constitutional system. It's a more subtle story than that, because European Union law will remain an enormous influence in the UK for the foreseeable future.
Professor Sajó, any comments? Would you have any comments?
Maybe I give a positive example how it can work and what can be a non-binding way of influencing a sovereign country. So in a complicated process regarding Turkey, the European Court of Human Rights decided that a person in detention has the right to counter from the very moment of being detained or arrested. This idea was very much present in France for 100 years, especially among members of the bar, and I guess among many criminals, but I'm not sure about that. And the police always resisted that. And of course, France is France, so the police had the last word. Now, once this judgment was applied to Turkey, and the Turks were ready at that time to follow it, this became a matter of embarrassment for France. It became a major weapon for the bar to push through with what they always wanted to have. And they were successful. So the French law was changed without ever being found in violation of the European Human Rights Convention. So I think there is a non-binding but still normative influence coming from globalization. Again, it can be very selective, it goes through resistance, but there are institutions which are capable of generating at least common principles, if not standards. And I think that is one of the very important elements in this globalization of constitutionalism. So it's not just a binding treaty, it's not just the EU setting for a region what is the law and influencing even the constitution, but there are these more subtle ways. And of course, the UN may have a little bit of that because again, with the reporting system, you have a certain pressure on states which do not like to be shamed, there is an international prestige element. But I think it's much more important the influence this kind of standard setting or shaming has on domestic constitutional politics, because each country has a public opinion that is divided, and some groups would like to move in one direction, others in a different one, and this becomes an argument, and a very important argument for the legal community and for society at large. So I think this is one way to, or one element of this interaction. Thank
you. So I think this leads into the next question, which I think Professor Stone, you mentioned you might be interested in. We often talk of, as Sajó was saying, even beyond the European Union, of this migration of constitutional ideas, right? Ideas around constitutionalism across borders and across jurisdictions, and they kind of have unpredictable influences in a domestic constitutional system. And there have been, a lot of metaphors that we've used to describe this kind of travel. Sometimes it's been called transplant, sometimes it's been called borrowings. Now it's, migration and, a constitutional dialogue that is supposed to be happening between different jurisdictions. So would you like to comment a little bit about this phenomenon, what you think about it? And then we can also ask Sajó to give his views.
I do think migration is a particularly good metaphor, actually, because it captures the idea that something comes from a place and it always, in a sense, has a memory of that place, but it then becomes something new again in the new place. And I live in a society that you can call an immigrant society or you can call it a settler colony, right? But I certainly feel that all around us all the time, that sort of sense of people having come from a place but making themselves anew in a new place. So, I think that captures a lot of what is happening. And if you think about an idea like proportionality, structured proportionality analysis, certainly there's been no idea that has been more successfully migrated around the world, and yet it becomes something quite new in each place. Australian proportionality resembles not really at all proportionality as it's practiced, for example, in the Federal Constitutional Court of Germany. It's quite a different thing by the time it has migrated all the way to Australia and been taken into a very different judicial culture, a very different form of constitutional review, where we've got diffuse constitutional review through the courts rather than a specialist constitutional court. All of these things, in quite surprising ways, make proportionality analysis something really quite different. So one of the real kind of joys of studying comparative constitutional law is to actually trace this development and understand both the roots of an idea and yet also its local resonance.
I had another example to that. Of a recent idea that's been propounded by Stephen Gardbaum, who is in fact a British academic, but who's had his entire career, I believe, in the United States. But he's proposed a model of what he calls new Commonwealth constitutionalism, which he sees as essentially seeing a kind of role for courts in protecting constitutional rights that lies somewhere between the kind of the British and to an extent Australia when it comes to human rights in the absence of a federal Bill of Rights tradition where essentially rights are primarily a legislative matter. The protection of rights is to be achieved through statute primarily or through common law. And on the other hand, the kind of German or US tradition of full-blown constitutional review, also, as I believe practiced in India. And he's kind of located this idea of an intermediate stage, of which the first main example was obviously the Canadian Constitution and notwithstanding clause, where in theory the legislature could override a decision of the court, not ever used, of course, at the federal level. I believe it has been used at provincial level a few times in Canada, and there's a lively debate about whether or not it still ever would or could be used. And then he says the UK Human Rights Act, which has been copied by some Australian states at state level, the New Zealand Bill of Rights Act, are all kind of variants of this where there's an attempt to give stronger protection for rights than you would get merely under kind of traditional common law approaches, but we're still leaving, in theory, the final word to the legislature if it wishes to exert itself. But again, as Adrienne was saying, when you look closely, the differences in the scheme can be actually, I think he does successfully trace a kind of common intellectual inspiration for such schemes. But actually, when you look closely at them, the differences, you could argue, are at least as significant, if not more so, as the similarities. If you compare, for example, in particular, the two ends of the spectrum, the powers of the Canadian Supreme Court as compared to the New Zealand courts under the New Zealand Bill of Rights Act, which is the sort of weakest of the models, are remarkable. So it's very interesting. Scholars kind of engage with it and dispute whether or not it's sort of the differences are more significant than in fact the overall similarities. And the final point, I think the whole thing in a sense drew its inspiration from a negative source of influence, which is observers looking at the kind of politicization of the United States Supreme Court as a kind of famous example of an extremely powerful constitutional court, and also the way in which there's been, appalling decisions by the Supreme Court at times in its history, or extremely controversial decisions that effectively can't then be undone through democratic means. So then you end up with this squabble over who shall appoint to the Supreme Court, which has become, as we saw, particularly for a long time, but reaching its apogee under the Trump presidency, becomes the kind of, the defining feature of a president is to get some judges on the Supreme Court. So democracy will still try and have its way, in a sense, but unfortunately, this is probably one of the worst ways you could try and have democratic control, in this terrible squabble over who appoints to the court. But I think that was part of the inspiration, actually, the negative example, and countries like Canada and Britain not wanting to have something better than they would have had just under common law, which had proved itself to be kind of very weak, but not wanting to go as far as the United States, because of the sort of several negative constitutional examples that are well known from that particular kind of system.
Yes, I was just wondering, so migration in a way, especially if it's happening from the global north to the global south, because many of the former colonies and so on didn't have a tradition of democracy and so on. When they looked at these iconic precedents, the US or UK and so on, to the extent that they felt that constitutionalism meant having something like the Westminster model or something like the US Constitution, it was a kind of a conversation stopper. So it didn't let the regional or indigenous ideas develop to the point where it really had enough significance. So I don't know if it had a kind of a chilling effect as well. Just looking at precedents that were already out there, if constitutionalism was so closely associated with these iconic precedents that you couldn't think beyond that, and think of constitutions in a different way, which might have been better suited for local conditions.
I think you've just made a really, really good and important point, and that is this process of migration reflects real political and cultural power, and it is the politically and culturally powerful who are influential, and part of our job as scholars is to be very critical about that power dynamic. And you're absolutely right that it is migration from the global north to the global south that has been the dominant dynamic. One of the exciting things about, if you read Ran Herschel's book about cities, for example, is the very possibility that it is the dynamics of the global south that in fact could be really important also for the global, not for the world, including the global north. And I think that's a very, exciting turn for comparative constitutional law scholarship to take. And it's one on which I certainly hope global south scholars will lead, and that global north scholars will be critically attentive to.
Professor Sajó, any comments before we go on to the next question?
I think we have a lot to cover, and we will have to, yeah.
Okay, I think the next question really is for you, Professor Sajó. So these are about how the question is about judicial references to foreign precedents. How appropriate do you think they are? Because you have this, we always, I talk to my class about this, the Justice Scalia versus Justice Breyer debate about, how democratic is it for you to be looking at, precedents which were developed in a different legal system. The domestic, there is no consensus on, the kind of approach that you have in a foreign country. So are judges justified in looking to foreign jurisdictions when they're deciding, some new case or new issue, which might not have the consensus, from their own populations, from their own countries?
My perspective is very provincial because the European Court of Human Rights has its own area of jurisdiction, 47 countries, but they have a certain legal commitment because they ratified this convention, which refers to some common traditions in its preamble. So there is some ammunition to argue that at least some minimum standards can be developed from what is out in the field. Other countries are not bound by a similar legal obligation. So whatever I say is is difficult to extend. Now, for the 47 countries, and of course the same applies in a very different way to the European Union member states, which are all part of the Human Rights Convention. The development or finding of common traditions is a very complicated matter. And it is, of course, based on precedents of different countries, although in reality, what the European Court does most of the time is just positive black letter law and much less a systematic comparative study of the jurisprudence of the state. So cases may be cited, but this is not typical. In the member states of the Union, not because of Union membership, or in many countries that I know because of this European system, the 47, there are very often references to other countries, but I think this is not different from what happens in India and Pakistan in particular, that these are very selective choices. These are not systematic. These are intended to serve a specific argument. They are supportive of what the court concludes. So it is inevitably somewhat biased. Even if you see a certain review in many constitutional court judgments of it remains selective. I've seen this even at the level of quoting the case law of the European Court of Human Rights. So many constitutional courts in Europe do analyze, they have to, the judgments of the European Court. This applies to the Supreme Court of the United Kingdom as well. They do a decent work, by the way. But other countries, they tend to forget some of the judgments we used to, the court renders. I'm not anymore there. So it is, again, rather selective. That's part of the game. And we should be aware of what is going on. I mean, this is not a theoretical statement, it's just a practical observation that precedents are selected. I guess it happens even when you refer to specific precedents in your domestic system coming from your own constitutional history. Some cases are just not mentioned. And this is even more true when it comes to comparative references in both constitutional and in international bodies. So that's I think a part of the reality.
If judges tend or select certain jurisdictions and look to foreign precedents, is it possible that because of their unfamiliarity with foreign modes of analysis or the context, there can be some illogical or inconsistent applications of foreign law? Is there a danger of that happening at all?
Well, that's exactly what I was implying, but it's better that you formulate.
Okay. Okay. Professor Stone or Professor Phillipson, any comments?
So let me say, I think that is a problem. It's just not an insurmountable one. I think, I can think of instances where, looking at the Australian courts referring to foreign jurisprudence, that they can sometimes forget really critical things like differences in jurisdiction between the courts that can really affect outcomes. And so, but what it requires is just a careful critical comparativism. It's a very difficult task for judges. And I really believe that, on top of being on top of all the law of their own country, suddenly they need expertise in the law of other countries and the capacity to compare them. I really think one of the things that scholars need to do is devote themselves to providing some of the research infrastructure that enables courts to make good comparative decisions. I think there just simply is no point in kind of like pulling the shutters down and say we're not looking anywhere else. It denies the reality of the globalized world we're living in. But we also have to be sensitive to the difficult task that we're placing on judges and also on litigants if we're asking litigants to argue in this way. And it's one thing that, as a scholar, I want to take seriously, that part of what we need to do is provide others with support to understand the comparative enterprise.
May I add something?
Yes, please.
Gavin was going.
Oh, well, I was just going to agree strongly with what Adrienne just said, and particularly the role of academic scholars to try and provide a more systematic and, as it were, cautionary basis for comparativism. In other words, pointing out the possible pitfalls, because when you just leave it purely to litigants and judges, you get the danger of kind of opportunistic comparativism, because obviously counsel who want to win their case will reach, if they're reaching for something, they'll reach for something that is helpful. The judges may reach for things that support what they wanted to do anyway. So that can be very kind of opportunistic and not done with any kind of, not done in a systematic way and not done in a critically reflective way, as Adrienne was reminding us, is essential. And that, I think, is where the role of academics can come in, to try and provide an architecture or an infrastructure for that to be done in a much more systematic and critical way, with awareness of the dangers of constitutional transplants, because it can happen rather opportunistically and almost sometimes by accident in the course of litigation, because of the fact that counsel just want to win their case, which is their job after all. So they will use anything that they think is useful, and judges may may be receptive to that, especially if it confirms the way they're thinking anyway.
So if I may, and I promise for the other questions, I will not take the time of colleagues. Take the decision of the European Court of Human Rights on abortion in Ireland. It's called ABC versus Ireland. So there is a comparative study indicating that 94% of citizens in this huge space do have access to reproductive services. There are five countries which do not allow that, but one is San Marino, 30,000 people. The other is Malta, I think 300,000. Biggest is Ireland, with all due respect. The ordinary standard of the court is that where there is a European standard, then there is no large margin of appreciation. So from the perspective of comparative studies, I think even a most court-friendly academic will say, yes, there is European consensus. This is an outlier island. So what is doing the court? After having presented impeccable overview of the European scenery, they say, well, but this is a different problem because this is a sensitive matter. And therefore, because it's sensitive, European consensus doesn't apply. So, you know, even where there is compelling empirical evidence, there might be legitimate or less legitimate. I was not part of the composition, so I don't want to burden you or bore you with my take on this, but it is clear that there is a, against the empirical normative power of what emerges from comparative studies, courts just, which may claim that this is relevant, suddenly invent a new normative perspective. So I think we really have to understand that here, the comparative study pushes courts to new normative assumptions. And I think this is part of the realities. It's not just that the academia has to be critical of the methodology, which is very poor. Here I can be very open, very poor in this area when applied by courts. But I think criticism shall include the normative aspect. So to what extent is this of normative power? That I think is really part of comparative constitutional law or constitutional studies. Thank you.
Unfortunately, we have 3 minutes left. I don't think we have too many questions from the audience. And the one question that we have is, you know, I think we've pretty much addressed that. So maybe we have time for one last question. I mean, I think I can kind of condense 2 questions. And this is more about, you know, comparative constitutional law research. And so you have these, you know, methodological approaches that we often talk about, you know, classificatory, historical, normative, etc., functional, contextual, expressivist, and so on. So what would you say is the best, you know, for comparative public law scholars, the best methodological approach? And I know Ryan Herschel has a lot of criticism about, you know, problems with case selection and research design as far as comparative public law scholars are concerned. So how do we come up with a methodology that is rigorous enough in this area? And just to end, what do you think would be the value of doing comparative public law research? So is it to arrive at certain universal truths, to improve or reform the quality of one's own constitutional jurisprudence? Is it to get an insight into the experiences of other legal cultures, including non-Western legal cultures, so as to better understand certain notions of, say, equality or consent? You know, these are kind of inherent elements of constitutionalism. So do we get a better understanding of these, you know, normative ideas by doing comparative study? Is it also to, you know, improve the quality or the state of the law in one's own country? So that would be my last question. And I would ask perhaps all 3 of you to briefly comment before we end today. Professor Phillipson, would you like to start, or Professor Stone, would you start? Would you want to start?
I think Professor Stone was just about to speak then, and she's far better qualified than me to speak on this topic, so I defer to her.
Excuse me for jumping in. So look, there is no one comparative constitutional method. There are many research questions that you might ask in the course of studying constitutional law globally, and then you need to make sure that the method that you adopt is the one you need to answer your question. And I think you referred to Ryan Herschel's wonderful book, Comparative Matters, where he makes a very strong case for adherence to case selection principles, which is really, really important if you're doing inference-oriented comparison. You know, if you're going to draw a kind of causative inference from your study, then you need to make sure that you've selected cases in ways that can support that. And that's very valuable to bring those social science principles into comparative constitutional law when you're doing that kind of comparative constitutional law. But you may not be, right? You may be doing something that's more normative. So one really important thing to do, and my scholarship tends to take this moment, is actually to use comparison as a way of uncovering competing normative ideas about constitutional principles, right? So, and if you're doing that, not trying to draw a causative influence, but to try and understand moral fundamentals, then you might draw case selection principles in quite different ways. And so it's really important to look at that. That was an incredibly significant intervention in the field. But I do think that there are actually more than one method that we ought to be considering as we do our work. And the question is, how do you answer your question? And if your question requires you to look comparatively, then you think through the method as to how it is that you do it. So I don't think there's one method, because there are too many interesting questions.
Right. And just a brief comment. So what would you say is the value of doing comparative public law research? Because sometimes we think every country is so different. How do we even start to compare? It's so contextual, and you have to look at the social and political histories to even understand where all these public law arrangements, where have they come from. So is there a purpose to doing comparative work? Is it something, we can look to understand normative concepts better, to draw lessons for our own jurisprudence? What would you say would be the value?
There are many purposes, right? You can do all of those. It may help you construct your own constitutional law more intelligently, precisely because it might dispel a false sense of necessity by understanding that things actually can be done differently, and see that what you think is necessary is not necessary. That's just one thing it might do. It may help you in constitutional design. It may help you kind of unpick different moral visions of constitutionalism. And it may help you draw causative inferences about what causes success and failure of certain kinds of institutions. They're all really different questions. They're all really good questions, and they're all really good reasons to do comparative constitutional law. I really think that calling the field comparative constitutional studies, and I want to pay tribute here to the foundation director of the centre that I direct, which was Cheryl Saunders. She founded it in 1988, and she called it the Centre for Comparative Constitutional Studies because she understood the breadth of this field. And so I would encourage everybody to think of it as a really plural field in that way.
Any further comments before we end the session today?
Just to heartily second that, yes. I think
Sure,
multiple
absolutely.
different purposes can be served by comparative public law. You might be wanting to solve a particular problem that's arisen in your own country, looking for ideas elsewhere. You might be wanting to uncover historical or normative roots that are common to several countries or differ sharply. I think, yes, open-mindedness to that. It's a very rich. There are several rich possibilities for which you might engage in it.
Thank you so much. I think we are, unfortunately, there are so many other questions, but I think we have reached the end of this session. Just a 1 hour session is absolutely not enough to address all these questions. But thank you so much, all the panelists, for taking the time and to be with us, Professor Sajó, Professor Stone, Professor Phillipson. I know that it's different time zones for all of you, so it was quite a task to kind of fit all of you in together. And I just hope we have another chance where we can, meet again, maybe for a more extended session, now that we've connected with you. But thank you so much again.